So with respect to the amendments that deal with leaves of absence, the proposed amendments to the Employment Standards Act are part of an overall overhaul of the legislation that relates to that kind of stuff, if I can put it that way. And it begins with the updates to the Employment Insurance Act. So June 2013, the Employment Insurance Act was updated so that an employee could take up to 35 weeks off to provide care or support for their critically ill or injured child. So prior to this, you could not collect employment insurance to provide care for your critically ill or injured child. With the update to the Employment Insurance Act, the Canada Labour Code has also been updated. And the Canada Labour Code, unlike the ESA, applies specifically to federally regulated employers, so freight, telecommunications, broadcasting, airports, anything that comes within the ambit of the federal rather than the provincial government. So the corresponding update to the Canada Labour Code is to provide leave where a parent needs to care for a critically ill child, or to provide a leave where a parent has suffered from the death of a child or the disappearance of a child. Unlike the leaves I'm going to be talking about under the ESA, these are already law. So the leaves relating to crime-related death or disappearance under the the Canada Labour Code apply to employees who have been employed for at least 6 consecutive months. If the employee's child dies as a result of a crime, they're eligible to take up to 104 weeks off. If the employee's child disappears as a result of a crime, they're eligible to take up to 52 weeks off. Now, there's an important exception under the Canada Labour Code where if the employee is charged with the crime that results in the death or the disappearance of their child, they're not entitled to take any time off. It's also important to note that the word used here under the code is charged, so you don't have to be convicted. Of course, if an employee is convicted of the death or disappearance of their own child, they'll be in jail. It doesn't matter what the Canada Labour Code says, they're not coming to work. So, corresponding amendments to the ESA. These are not law yet. They're close to there. They're on the 3rd reading. After the 3rd reading, they need to receive royal assent, and then they can become law. So they expand family medical leave, critically ill child leave, crime-related death or disappearance leave, as we were just speaking about under the Canada Labour Code. And it's also important to note, and I started by mentioning the amendments to the Employment Insurance Act, these are unpaid leave. So the Employment Insurance Act provides a means for employees to receive some form of remuneration while they're off. These simply say you can take the time off work. So in terms of dealing with a critically ill or injured child, up to 8 weeks will be available if Bill 21 passes. Qualified medical practitioner, of course, has to provide something in writing. And the definition of family member under this amendment is fairly broad. It includes the employee's spouse, child, mother, grandparent, etc., even step-grandparent. It doesn't, of course, include your neighbor, your dog, whatever, your friend. And critically ill child care leave as well is being added to that. And critically ill child is defined as one whose baseline state of health has significantly changed and whose life is at risk as a result of an illness or injury. Up to 37 weeks is available, and of course that applies only to employees who have been employed for at least 6 consecutive months. Again, as with a family member who's suffering from a critical condition, something in writing from a medical practitioner is necessary. The definition, and this is not the definition of qualified health practitioner, is also proposed to be amended. Currently, you need a note from a doctor. If the amendment passes, I believe a psychologist can issue a note as well as a registered nurse. So, now the proposed amendments to the ESA that deal with crime-related death or disappearance are exactly what we saw under the Canada Labour Code. I'm not going to go through them in detail. detail, but again, it's 104 weeks for death, 52 weeks for disappearance, and again, there's that exception which disqualifies employees. So those are the new leaves of absence. But there are a large group, and I can't summarize them in any sort of concise form, a large group of proposed amendments under another bill, Bill 146, which we're seeing coming down the pipes in 2014. This was only introduced in this past December. It's in the process of the first reading, and it'll take some time, of course, for it to go through the second reading, the third reading, and then royal assent. So we may not be seeing this for a while. I also understand that some of my colleagues have been in touch with Ministry of Labour officials, and they really have no strong view about whether it's likely to pass in its current form. But I'll go through what the proposed amendments are in their current form, and you can make your own assessment. So the first thing that would do is it would remove the 10,000 order to pay cap on recovery of unpaid wages. So wages is defined fairly broadly, includes vacation pay, termination pay, etc. Under the current cap, an employment standards officer can award no more than $10,000, no matter how much an employee is owed. Under Bill 146, there would be no cap. So, for example, a 10-year service employee who claims termination pay is going to be entitled under the current ESA to 8 weeks termination pay, 10 weeks severance pay. For the sake of example, we assume they make $10,000 per week, they'd be entitled to $18,000. Under the present Act, a Ministry of Labour employment standards officer can only award $10,000. So in some cases we can be talking about significant amounts of money, and so it will be helpful, hopefully, to broaden what an employment standards officer can do in that respect. Increasing the time limit for wages is another proposed change. It'll be increased from 6 months to 2 years. More significantly, though, under the proposed amendments, an employment standards officer will be able to direct, by written notice, an employer to complete an ESA self-audit. And that would include reviewing practices, procedures, or both. Essentially, it's a self-reporting mechanism. They can direct how the audits to be performed, and they can require that a written report be actually submitted to the Ministry of Labour that sets out any violations that an employer finds in performing the self-audit. The interesting question is, of course, what do you do if you find an Employment Standards Act violation and now you're going to the Ministry of Labour and saying, well, look, my company is violating the Employment Standards Act. Typically in Canada there are laws that allow us to avoid self-incrimination, and so it's not clear, and because the bill is very new, it's not clear if the Ministry of Labour prosecutes, for example, on the violation of the Employment Standards Act, whether that report can actually be used as evidence in convicting. Of course, it would be very damning if an employer says, well, I've committed this violation, and the Ministry of Labour says, aha, you're guilty, we got you, we don't need to do anything else. In any event, I think the advice, and especially given that you're hearing from group of lawyers today, if this passes and you were to discover a violation in your workplace, contact a lawyer, be careful about anything that you submit to the Ministry of Labour, and hopefully we can be of some assistance. Further amendment will require employers to provide ESA posters to employees within 30 days of their hire. These are the posters that set out minimum wage, vacation, entitlements, all of that kind of stuff. It'll be available in 23 languages, and if you need one in a language that is not presently available, the employer will have an obligation to contact the Ministry of Labour and see if it can be made available. And the last amendment, which is sort of interesting, is that the proposal is that there would be joint and several liability between temp agencies and employers for unpaid wages. So if an employee comes to work for you through a temp agency and you're expecting the temp agency to pay and they don't, the employee would potentially be able to make a claim against both the employer and the temp agency to try to get those wages recovered. So in any event, those amendments under 146, as I say, they're broad and they encompass a lot of things. We don't know what's going to happen with that right now. It's very early, but it'll certainly be interesting to tell. So, moving on to the final part of my presentation is to speak briefly just about a couple of recent key cases that have come out that interpret the operation of the Employment Standards Act. And the theme of the two cases I've got up here on the slide is be careful how you draft your termination clauses. And I say termination clause, I mean clauses that apply when an employee is terminated, typically part of an employment contract that's entered into at the time of hire. And the underlying theme of both the cases as well is that you cannot contract out of the Employment Standards Act. The first case is Stevens and Sifton. This was a wrongful dismissal case. It involved someone who was a head golf professional at a golf club. She'd been employed for, I think, about 26 years, I believe it was, and had worked her way up to that position. She was terminated without cause after 26 years, and so, of course, sued her employer. And the key issue in this case was whether or not a particular termination provision applied. So, as I assume most of you are familiar, if you're terminated without cause at common law, you're entitled to reasonable notice or pay in lieu of notice. If you've been working for 26 years and you're in a relatively senior position, this employee could be entitled to anywhere in the range of 24 months notice. In a few cases, even more notice has been given. If the employee is terminated if the contractual provision does not apply, then the notice period is higher. If it does apply, then it limits the entitlement. So that provision reads, the corporation may terminate your employment without cause at any time by providing you with notice or payment in lieu of notice and or severance pay in accordance with the Employment Standards Act of Ontario. And part of the reason this is interesting is because you read this provision and you think, okay, well, I started out by saying you can't contract out of the ESA. It looks like this is a clear, or the clear intention is actually to comply with the ESA. There's no intention to contract out. And under the Employment Standards Act, termination pay, and I'm not sure whether there is severance pay available in this case, but termination pay would be 8 weeks. There would be some amount of severance pay, nothing approaching what the common law would offer in terms of 24 months or something in that range. So, is this contractual provision enforceable? And of course, the reason I'm talking about it is because it's not. The no contracting out provision I've got up here on the screen, Section 5 of the ESA, subject to subsection 2, no employer or agent of an employer, no employee or agent of an employee shall contract out of or waive an employment standard, and any such contracting out or waiver is void. So, again, you might think, well, what's the problem? It looks like they're trying to comply with the ESA. Well, the provision doesn't mention benefits. So, and this may be too small for you to read, but what it says is, an employer may terminate the employment of an employee without notice or with less notice than is required under the relevant sections of the ESA if they pay termination pay, and B, continues to make whatever benefit plans would be required to be made in order to maintain the benefits to which the employee would have been entitled. So, going back to that provision, it just says terminate without cause at any time by providing you with payment in lieu of notice and or severance pay in accordance with the Employment Standards Act. It doesn't say anything about benefits, and I didn't add, perhaps should have added, it also said in the employment contract, and it would say in all such contracts, this is your sole entitlement upon termination. So, the result was, again, the clause was void, and the employee was entitled to common law or reasonable notice pay. We actually don't know what that was in this case because the decision of the court was on a motion for summary judgment, and the narrow issue was simply whether that provision applies. I don't believe there was any trial decision as to the total amount of entitlement. So the next case I'll speak about very briefly is Wright and the Young and Rubicam group of companies. This is a similar case involving a similar termination provision. And so the facts in that case, they involve the president of the company, 49 years old. He worked there for 5 years, I believe. And he was terminated. He was provided with 13 weeks of base pay, RSP contribution benefits, and car allowance. And that was pursuant to termination provision, which is relatively lengthy, but essentially it provided increased amounts of pay based on a sort of sliding scale, depending on how long he'd worked there. It didn't specifically set out would simply comply with the ESA as the previous one did, but there was some effort to make sure that that amount of pay was always greater than what's set out in the ESA. So after 5 years, the contract provided for an employee 5 years or more, and up to 10 years after commencement of employment, they'd be entitled to 13 weeks base salary, plus a bunch of other stuff. So, is this provision void? Yes. As with the previous example, there's no mention of benefits in this. But there was a further issue as well. So because we have a sliding scale, you're entitled to 13 weeks of base pay in these circumstances, you're entitled to 2 weeks of base pay in these circumstances. The court went through and they actually did the math for every combination of what an employee might be entitled to. And they found out in a couple of cases, and the example here is, if the employee had worked for 8.5 years, the contract would provide for 16 weeks of base pay, but under the ESA, they would have actually been entitled to 16.5. And so it appears that the employer didn't do their calculations correctly in going through this, and the court found that in some cases, this would provide the employee with less than they would be entitled to under the ESA. And in this case, senior employee, 5 years of service, the court found he was entitled to 12 months of pay in lieu of notice. So, wrapping up the tips that I relate, first in terms of Employment Standards Act or compliance, conduct random ESA audits yourself before the Ministry of Labor comes knocking, especially for high-risk areas like overtime pay. Post the ESA poster in your workplace. It's available online, PDF. You can get copies from the ministry. It's easy to do. And the last one is, of course, to ensure that you have proper employment contracts in place with carefully drafted termination clauses. We've seen as lawyers how often this comes up in the jurisprudence, and we're, of course, available to assist in any way that we can. So that concludes what I have to say. I'll stick around afterwards if there are any questions. And up next, we've got my colleague, Marty Rabinovich. He's going to talk about a couple of my favorite topics, sex and drugs.